really kind of sums up what this is about. I quoted Jeremy Bentham, jurist and philosopher, who wrote, quote, "Secrecy, being an instrument of conspiracy, ought never to be the system of a regular government." The facts are pretty clear. What happened was my client, who is chairman of the Thurston Conservation District, and the board auditor learned that Washington State University maintained what is known as a vault of data at their offices here in Olympia. They went down on January 25th seeking records. At the time, they notified one of the IT director, Mr. Colombo, that they were investigating staff for misconduct, including the interim executive director. At that date, same date, the interim executive director was there, to their surprise, and told IT staff to route all requests through her. And they did, to the detriment of my client's rights under the Public Record Act. They treated the interim executive director as if she was the requester. Now, what's noteworthy, Your Honor, is that WSU's own Assistant Attorney General and one of the deputy directors at the Department of Energy warned staff that the interim executive director should seek legal counsel, and if she wanted to intervene, to seek an injunction. She didn't do that. What happened here is that staff willingly capitulated their statutory obligations under the law and deferred to the interim executive director. As I noted in my reply brief, she didn't need an injunction when she had the IT staff in the bag. I know we could go through, and I know Your Honor read all the materials, so I'm not going to repeat everything, but clearly, as illustrated by my reply brief, WSU received my client's request for information. It is recorded in their own database called NICS request. I provided that attached to my reply brief. So any idea that Mr. Colombo or Mr. Pearson didn't think this was a public records request is nonsense for a number of reasons. First, it's in their own database that was received on January 31st. Secondly, you look at the behavior of Mr. Colombo and Mr. Pearson, where they emailed the interim executive director about the request, and they even entitled it public records request or request for my client, Mr. Johnson. What is curious, and I mentioned this in my briefing, is that Pearson obviously had some qualms about this. He said in his email, how is this going to work? You know, because the interim executive director wasn't the requester. My client was the requester. And rather than respond pursuant to the statute within the statutory time limits and communicate with him on any need for clarification, they communicated with the interim executive director, who again was under investigation for alleged misconduct. And as noted in my opening brief, this isn't anything new. The Olympian years ago did an expose on how these small government entities are fruitful vineyards for mischief. I think what's important to note is after I filed my opening brief, WSU Energy did a document dump of about over 2,000 new documents. Now they had opened my client's public records request, they closed it. Then they get my brief, they open it again, and they dump another 2,000 documents. The first batch, Your Honor, let me just say, included such interesting ideas like environmental studies on freshwater mussels, which I'm sure was responsive to my client's request. I think the total, you have the number, I think it's 6,000 or 7,000 documents to date. But I think it is telling, after I filed my opening brief and after we agreed to this scheduling order a long time ago, that they do another document dump. And of particular interest was the interim executive director's response to my subpoena. And this, as I put in my reply brief, was an oh my God moment for me. I've never seen this happen in 35 years of practice where a party advises someone not to respond to a subpoena. I think to give WSU some credit, its AAG did advise staff, she's got to get an attorney. If she wants to stop this disclosure, she's got to get an injunction. Problem is, they had already been co-opted. They were already cooperating. And it's manifestly illustrated by the interim executive director's email to WSU Energy IT staff not to cooperate with my subpoena. This is very disturbing, and but the question at hand here is whether or not the requests were properly submitted. Simple answer, yes. Their database said it was. Remember that my client submitted the request to Mr. Colombo because he signed the agreement. He was the signature on the agreement. Mr. Colombo didn't refer my client to WSU's public record officer. He referred my client to the interim executive director who was under investigation. And my client, I think to the surprise of WSU, never made a request back there because he knew it would be screened. What my client did know, it was that his requests were already being screened. The second issue is whether the email on January 31st provided fair notice that was a request made under the Public Records Act. Again, their own database says this. The answer is it says it was received on the 31st. This is the next request database which WSU proudly talks about. The third issue is whether the records requested by the plaintiff are public records.
Mr. Meyer, I'm just going to stop you for one moment.
Sure.
When you're referring to the document that reflects that there was a records request made on January 31st.
Yes.
In the records from Washington State University, where is that?
It's on page 1 of my reply brief. You'll see under received. I have.
There we go.
Yeah, you'll see received January 31st via email.
I see it now, thank you.
Yeah. And I think that's critical. I mean, obviously my client didn't put it in there. Someone entered that. So, so to answer the question whether my client's January 31st email request provided fair notice that was a request for public records is answered by their own documents. The way this works, Your Honor, a requester actually gets a special, you're aware of this, they get a special link where they can track and look at the data. Getting back to the third question, whether the requests are public records. Well, this is an interesting question. I know WSU wants to make a big deal about this.
I'll let you save that argument for reply.
Oh, okay. Thank you.
I mean, that portion, if you have anything else to argue,
okay.
but I'll let you save, whether or not
Okay.
it's a public record, I'll let you
Okay.
save that for reply if I need to hear any argument.
Okay. All right, so let me go on to the next ones. Number 4, whether the records requested by plaintiff are defendants' public records. Bottom line, they're retained by them. The statute is broadly interpreted. They have them. This is not a private entity.
You don't have, I'll let you
Okay.
save that portion
Okay.
for reply.
Okay, let me go on to number 5. You stop me if you want me to say it. Whether defendant violated the PRA by failing to produce the request of records, clearly yes. The bizarre thing, Your Honor, is that they have 5 days to get back to my client. Rather than get back to my client, they got back to the interim executive director, as if she was the requester. She wasn't. There's Pearson got back to her within a few days, like February 2nd or something like that. did not get that from my guy. And that was all based on the interim executive director's meeting with them on January 25th, where she told them in no uncertain terms that all requests are supposed to come through her. So that's, and I'm not going to rehash the history where they opened it, they closed it, they opened it again, and then they dumped over 2,000 documents on me after I filed that opening brief here. The sixth issue is, if the court finds the defendant was obligated to produce records, what records was the defendant obligated to produce? Clearly, they still haven't produced the metadata for this particular document. They, ironically, in their response, they attached that document. And the document has some defamatory information concerning my client. My client wants the metadata for that. We've asked for it repeatedly. Quite frankly, I don't know what the problem is.
Isn't the problem as it relates to that specific issue is that that's not what your client requested. Your client made a very specific request indicating when the email, I think, was initially drafted, and then when it was sent, he had a time and date, and that there was not a document that matched that. And so my understanding of the state's argument is they had nothing to fulfill the request, which is why they didn't provide the metadata, because the document your client specified didn't exist.
2 points, Your Honor. You know, under the statute, the agency is supposed to reach out and try to get clarity with the requester. They reached out to the interim executive director and told her, can't find it. But they also said if we had some more information, we'd be happy to look for it. She didn't pass that along to my client. My client would have pointed out where exactly it was. They did produce it in the first batch of materials. In my opening brief, I mentioned that. This is it. And so it's mentioned in the opening brief. Clearly, since they did the document dump after my opening brief, they could have included the metadata. I don't know why they didn't do it then. So even accepting WSU's claim they didn't know what document my client was referring to, they had an obligation to inquire with the requester. They didn't do that. Number two, I identified it in my opening brief. They didn't follow up, even though they did a document dump of other materials. And as I said, they attach it. Ironically, they attach it to their materials, which is mind-boggling. Your Honor, as you indicated, you've read the materials, and I'm here to serve the court. If you have any questions, I'd be happy to answer those.
I don't have any questions at this time.
Thank you.
Thank you. Mr. Fulmer?
Good morning, Your Honor. Assistant Attorney General Tim Fulmer on behalf of Washington State University. The university would ask that the court find that it did not violate the PRA and dismiss Johnson's claims today. There are a number of threshold issues that the university raises and arguments about why Mr. Johnson's request was not valid under the PRA, as well as why it was not a request for public records, for the university's public records. But I do want to focus on the manner in which this request was submitted to the university. The university has a public records office. It is in Pullman, Washington. It is staffed by specialists who are experts in the Public Records Act and respond regularly as part of their duties to respond to public records requests. The university accepts public records requests by phone, it accepts public records requests by mail, and it has a website by which individuals can submit public records requests to the university. It is not hard to submit a request through the university's processes. And the Public Records Act requires agencies to publish procedures by which individuals can submit Public Records Act requests. That is RCW 4256-040. It also allows 040.
Thank you.
It also allows agencies to pass reasonable rules in terms of handling and responding to public records requests. And when an agency designates a person to whom requests should be submitted and the requester fails to follow that reasonable rule, the request is invalid. That is based on Harmley versus Clark, in which an inmate made a public records request to two staff members and argued that the staff members themselves should have accepted the request and responded to them, and the court rejected that argument and found that those requests were invalid because they were not submitted according to the Department of Corrections reasonable rules.
Mr. Fulner, in the reply brief, the plaintiff has argued that that case should not be authority or persuasive because there was either a different statute or a revised statute that was enacted after the Parmalee case. And then it talks a little bit about may and shall in the reply brief. What is your response to that?
In terms of the statutory argument, that's just incorrect as a matter of fact, Your Honor. That statute was in existence as presently codified prior to the Parmalee decision. I believe it was last amended in 2007. In terms of the should versus shall, the discretionary versus the mandatory, I believe that the requester is reading into that statute, which says that which is designed to require agencies to appoint public records officers. The idea that means that the requester does not have to follow the agency's reasonable rules. Because that statute was in place prior to Parmalee, I do not think it affected the court's analysis in Parmalee. Additionally, I don't think it really says anything about what happens when a requester doesn't follow an agency's reasonable rules. Ultimately, the idea that a requester should submit requests through a public records officer is good for both the public and for the agency. It's good for the public because it directs public records requests to the specialists who have knowledge of the records that the agency maintains, as well as the Public Records Act and its applicable exemptions, procedural requirements. It's good for the agency because it allows the agency to ensure the requests get to the right person and that they're responded to appropriately. In this case, Mr. Johnson submitted his request to an IT manager in a satellite location of the university. According to the university's declarations from its Public Records Act staff, they learned of Mr. Johnson's request after this lawsuit was filed, and after they learned about it, they opened it in next request, and then they responded to it by gathering documents and producing documents in an extraordinary time frame.
Let me stop you there for a moment. Attached to the reply brief were what I believe are printouts showing different actions that happened through the system that WSU has set up to process their PRA requests. And so when it says that it says received January 31, 2018 via email on page 1, that information was placed in the database after that date when, I'm trying to clarify this in my mind, after the records department became aware of this request?
That is correct, Your Honor. If you look at page 11 of that same attachment, and then if you would look at also the declaration of Ms. Gleisman, they received the request on the 21st, then they inputted it into next request on the 22nd. So on page 11 of that same document, it says, request open, request received via email. It was at that point on the 22nd that they opened this item in next request, which was a day after the Public Records Office in Pullman received notice of the request.
All right, go ahead.
Because Mr. Johnson did not submit his request according to the agency's reasonable rules and regulations and failed to submit it to the Pullman office, it is invalid and the court should find that the university had no duty to respond. Second, Mr. Johnson's request did not...
Let me stop you there for a moment. I understand the policy argument. I understand the state's argument. What is your response to the fact that Mr. Colombo and or Mr. Pearson should have reasonably known that that was a public records request? Whether or not it was provided to the Public Records Office at WSU, I think part of the argument is how could this have been anything but a public records request when it was provided to them, both in a written form and then later by an email by the plaintiff in this case?
I think there are two important things about the request, Your Honor. First of all, it doesn't mention the Public Records Act at all in either of those documents. And the second is, in the context, you have a board member from an organization asking for the organization's own records without referencing the Public Records Act. In that sense, I think it's like the Grimaud case, the Grimaud versus Mason County case, where a union representative was asking for records from Mason County but did not clearly identify it as a public records request. So you have an individual from an agency asking for the agency's own records from an organization that just simply stores the records on behalf of that agency. And because there was no reference to the Public Records Act, it wasn't clear that he was requesting records under the Public Records Act as opposed to requesting just records in his role as board supervisor.
All right, thank you. Go ahead.
And that actually goes into my next point about the request not being sufficiently identified as a request made under the PRA. As I mentioned, the Grimaud case, the Court of Appeals considered two factors in determining whether an agency had fair notice of a request being made under the Public Records Act. Those factors are objective in nature. They test the characteristics of the request itself, as well as the characteristics of the requested records. Here, the agency received a request for records, but it was not clear that the request was made under the Public Records Act. Again, Mr. Johnson was the board supervisor of Thurston Conservation District, asking for the Conservation District's own records, which the university simply stored on its servers as a service to the Conservation District. That means that both the characteristics of the request itself, which did not reference the PRA, and the characteristics of the requested records, which did not, which were the Thurston Conservation District's own records, did not put the university on fair notice that this is a request for records under the Public Records Act. I'm also prepared to address the argument about whether or not these were the university's public records, unless the court would not like to hear argument on that issue.
No, you can argue that
Okay.
issue. I didn't have any questions from Mr. Newman on that, which is why I indicated he didn't need to argue it at that time.
So these are not the university's Public Records Act because they are not retained in the course of the university's own governmental functions.
So let me stop you there. I understand the state's argument. That's not my question for you. When I look at the plain language in this case and look at the word retain, I looked up retain under dictionary.com, thefreedictionary.com, merriam-webster.com, cambridge.org, and then Mr. Newman in his brief gave a definition from Black's Law Dictionary. In the Nissen case, the court used, I think it used the Webster definition. But in each of these definitions, the main portion is to keep possession of. That's dictionary.com. Thefreedictionary.com, to keep possession of, continue to have, as it relates to the definition of retain. Merriam-Webster.com, to keep in possession or use. Cambridge.org, to keep or continue to have something. And Black's Law Dictionary, to continue to hold, have, use, recognize, etc., and to keep. And so the definition of the public record, which is whether or not the document or the writing is used or retained by any state or local agency, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. When I read RCW 4256010 subsection 3, which is the definition of the public record, it appears to me that that statute is clear on its face. It's unambiguous, and so I can use the normal definition. And so it appears to me that the state is actually asking that I do something different to interpret or define the term retained on a statute that's unambiguous. And so that's my question to you. I understand what you want me to do, but it appears to me that under the requirements of statutory instruction, you're asking me to go outside what the court would normally do.
No, Your Honor. I think the key argument here is that it's retained in the use of the agency's business, and I think that comes from the Nissen case. And the reason that that makes sense is because it's retained, owned, used, or prepared. And if the word retain just merely means possess, I don't see how any of those other words are doing any work. We also know that that retain means retain in the use of the scope of an individual's employment based on a fairly recent case, Service Employees International Local Union 925 versus the University of Washington. which involved requests for professors' emails at the University of Washington. The court looked at whether or not those emails were retained in the scope of the individual's employment. That makes sense because agencies are inanimate entities. They have to act through their employees. If every record possessed by an agency's employees were a public record, that would lead to absurd consequences. And in this circumstance, where we're talking about...
Well, let me stop you there because it's the earlier portion of the public record definition that addresses that issue. Is that not correct? Because a public record includes any writing containing information relating to the conduct of government or the performance of any governmental or propriety functions. So if there's an email by a professor that is not related to the conduct of government or performance of any governmental or propriety functions, it would not fall under this exception, even if it's been retained. Correct?
That is correct. That would be one way for it to be considered not to be a public record. I would suggest that another way is that retained does not mean merely possession as well. And in this case, that makes sense and doesn't undermine the Public Records Act, because what you have is an agency performing information technology services for another public agency. Here, there is no real dispute that Mr. Johnson could just have submitted the request to Thurston Conservation District. The idea that somehow then they could have screened the request and not had, and Mr. Johnson would not have had any remedy is hard to fathom, because Mr. Johnson could always have filed a lawsuit against the Thurston Conservation District, and the Thurston Conservation District would have had to come into court and show that it complied with the Public Records Act. So the idea that an agency that merely performs information technology services and only retains those records on behalf of an agency would somehow undermine the Public Records Act. It just doesn't hold water, Your Honor.
And so, Mr. Polner, had Mr. Johnson submitted the email that he sent to, I think it was Mr. Colombo, had he sent that to the Public Records, Office of Public Records at WSU at their main campus, the response from WSU was going to be, this is not a public records request. We deny it because we retain these documents. They aren't ours. They're not public records. That's what their response would have been had he submitted it to the proper place at WSU.
Your Honor, I'm not sure about that. The agency, I don't think, had the opportunity to make that assessment at the time, which is why I think it would have been important for Mr. Johnson to submit that request through the Public Records Office. In this litigation, the agency is arguing that those records are not their own public records.
All right, go ahead.
In addition, in terms of whether the agency violated the Public Records Act by failing to produce all responsive records, I would submit that it did not. First, in its initial response, where it redirected Mr. Johnson to the Thurston Conservation District, that was not a denial of records. It was simply directing Mr. Johnson to the appropriate agency to whom Mr. Johnson could submit a public records request. And in fact, the Thurston Conservation District's interim director then responded and welcomed Mr. Johnson to submit a public records request to the Thurston Conservation District. That should not be considered a denial. In addition, Mr. Johnson has failed to show that there are any responsive records that are still being withheld. The only record that he's mentioned today is the record where he requested metadata, but as the court pointed out, Mr. Johnson's request was very specific. It requested a document by a specific date, and it was unclear to the university really until the reply brief if the email that it assumed Mr. Johnson was referring to was the actual email that he was asking for metadata about, because the dates did not match up. And Mr. Johnson, in his opening brief, referenced that email, but did not provide a copy of it. It was only until the reply brief that they said, oh yes, that is the email that we wanted the metadata on. That is the only responsive record that Mr. Johnson identifies as still being outstanding. Like I said, when the agency received the request through the proper process.
So let me stop you there. The reply was filed Friday, Monday? One of those days, right?
Last Thursday, Your Honor.
Okay, last Thursday. And Has the university, now that it was clarified for them what Mr. Johnson believed was outstanding, did they provide the metadata for that document, now that they're clear what the request was?
Not to my knowledge, Your Honor, no.
Why not?
I guess because there was this hearing and we were going to have argument about that issue.
But you indicated the only reason it hadn't been provided previously was because the university, it was a very specific request. That document did not exist. They didn't know. And the way you were arguing that, it was as if, had they known, they would have produced it. And now they have known for a week about, and they haven't produced it. So that's why I'm asking you, a hearing or no hearing, violation or no violation, why wouldn't they have produced it when they were finally clear what Mr. Johnson believed was missing?
Well, Your Honor, I guess I would say that the agency believed it had valid arguments about why the request was not properly submitted. If Mr. Johnson does now believe that he wants to copy the metadata of the email that's attached to the response, he can submit another public records request to the university. Ultimately, I think the university was waiting for this hearing and to see where it kind of went from here. It was quite clear that Mr. Johnson's request did not encompass that specific email. It's been kind of a moving target in terms of what he was seeking through that. Additionally, I would say it is kind of still ambiguous about whether Mr. Johnson is requesting the metadata from the actual email or the actual Word document attached to that. And there is some discussion about that in the declaration of Mr. Colombo, where he talks about Mr. Johnson showing him a document on his phone, and then he was asking clarification about whether he wants the Word document or the email documents metadata, and that really hasn't been clarified. They would have different metadata depending on which document he was seeking. Ultimately, the university, when the request was directed to the right people, promptly responded to the request by producing thousands of pages. It did so despite suffering a staffing shortage. They were below 2 employees, lower than they typically would be, yet they prioritized Mr. Johnson's request and provided him records in an expeditious manner after receiving the lawsuit. They did this despite not having received the request through the proper procedures, and because the request was not submitted pursuant to the agency's reasonable rules and regulations, the university would ask the court find that Mr. Johnson's request was invalid and the agency's response did not violate the PRA.
Thank you. Mr. Newman?
Thank you, Your Honor. A couple of points. Statute that you mentioned, I detail in my reply brief, uses the term may and shall. I don't think there's really any confusion there. It talks about how members of the public may direct requests for disclosure of public records to the agency's designated officer, and that the agency shall appoint such person. I think what opposing counsel is making as much to do about nothing. It is what we learn in law school about form over substance. He talks about the fact that the request didn't reference the Public Record Act. It doesn't need to. He makes a big deal in his response that it's not in the proper form. It doesn't need to be in the proper form. It could be oral, like he just said. And I think it's important to look at the facts here. The facts clearly show they considered it a public records request because the interim executive director told them back on the 25th, any requests got to go through me. And they did. They sent them through her. They labeled them as records requests. they referenced him as Johnson's PDR, you know. So add to that, their own database says it was received on the 31st. Now, I went back and looked at the declaration. The declaration just basically says we didn't acknowledge it until the lawsuit. Okay, why didn't they do that? Because staff was already working with the interim executive director in trying to address it in a way they thought was fit, but contrary to the Assistant Attorney General, and I would ask the court to refer to page 5 of my opening brief. I made a request, page 5 of my opening brief. I made this request to the Conservation District because they're not represented by the AG's office. And as you'll see here, to his credit, Mr. Malcolm, the AAG, said we want to expeditiously address this, get this done, so they're not going to be subject to a lot of penalties and court-imposed fines. What Malcolm didn't know was that, again, IT staff, they were already working directly with the interim executive director to route responses through her. So this argument that they didn't know or that they had no duty to respond, they were responding, for God's sake, just not to my client, which is the problem.
Mr. Newman, as it relates to that, one, I specifically asked the state to address the applicability of the Parmalee case, which you argued didn't apply.
Yeah.
Mr. Fulner said that the statute in question was in place at the time the Parmalee decision was written, so that's one. And two, as it relates to if it is then applicable, in that case, the person made a request to someone who was not the designated department for public records requests, and how does that interplay with this case?
Two things, Your Honor. I did a legislative history on that particular statute. As you referenced, it was recodified after the events in the Parmalee case happened. He made the request. It was after that that the statute was recodified. It wasn't referenced in the case, that the recodification, and perhaps because his activities predated, the request itself that Parmalee made predated the recodification. The recodification added this as a new section. It was a new section to the statute. I don't know why the court didn't mention it. Maybe it wasn't brought up. Maybe it wasn't in the trial record that was created. But if you look at the timing, the sequence of events, Parmalee made the request prior to that recodification. And so perhaps that's why it wasn't an issue in the Parmalee case. But clearly, the statute, as you've looked at, I've reiterated, talks about May. The facts here clearly indicated they treated it as a public records request. The fact that the WSU's public record office didn't acknowledge it until after the lawsuit doesn't mean it wasn't a request that was made. I mean, they were responding as if the interim executive director was the public records officer responsible for WSU's records, which is flat out wrong.
Okay, my last question is, it appears to me that the state, part of the state's argument is that the people in the energy program office were treating this as a request for records pursuant to the memorandum of understanding between the WSU Energy Program Office and the Thurston Conservation District, and that's why they weren't treating it like a public records request, because they believed it was a request pursuant to the memorandum of understanding.
And that's just contradicted by the facts, Your Honor. You look at Pearson's emails, he referred to it as a public records request when he was communicating with the interim executive director. So that argument that somehow it was a request for records that per the contract, you have to also remember when my client initially met with them on the 25th, I think it's 25th or the 31st, told them that he, as chairman of the board, and the board auditor were investigating the interim executive director for alleged misconduct. So I don't know how they could legitimately claim this was a request from the district. I mean, and quite frankly,
Let me back up for a moment,
okay.
because the Pearson declaration, page 3, paragraph 6, indicates, I did not interpret this email to be a public records request because I did not think that TCD's board would submit a public records request to obtain their own data.
Well, I think he's being disingenuous, because if you look at, in my opening brief, the communications between, for example, looking at Exhibit F to my opening brief. This is an email from Michael Pearson to Sarah Moorhead entitled PDR Public Disclosure Request and Board Members. This is not a request for records. And then you go on, Exhibit G is request for records in Eric Johnson. And again, what I wanted to emphasize with the court, if you read between the lines, Pearson was concerned how this was going to go down, because he said in the Exhibit F regarding the meeting on January 25th, I felt it was pretty clear from the meeting that you wanted all requests to go through you, meaning the interim executive director, rather than individual board members. Can you please give me a call when you have a moment to discuss how I should proceed? So I think Pearson was astute enough to know this was an aberration. There was something wrong here.
But doesn't that email actually lend to the supposition that he believed that he was being requested to do work pursuant to the Memorandum of Understanding, and that he was confused because such records normally would go through the executive director's request?
Two things. If that was the confusion, he should have communicated that to the requester, Mr. Johnson. He didn't do that. Under the statute, the PD Public Disclosure Act, they have an obligation to seek clarification through the requester. They didn't do that. Number two, if you look at the contract itself, quite frankly, it's poorly written. It doesn't address public disclosure issues, and I think that gets to a fundamental problem WSU has. They want to do this proprietary activity, yet not be subject to the public disclosure law. I mean, you can't retain records like a library or a vault as a public entity and say, oh, we don't really have those, even though they are clearly the custodian of those records. And the contract, which is provided, talks about services they provide, including access if you need to and everything. That's their business. That's their business plan. Unfortunately, they're a public entity. If they're a private entity, then that's fine. And as attorneys, we know that cloud computing can present problems with privacy issues. But cloud computing normally deals with a private host. Here you have a public host. That is the fundamental flaw in their business plan.
All right, thank you. This matter is before the court for the full Public Records Act hearing in this case. The matter was well briefed by both sides, as well as there were significant exhibits that were submitted as well for the purposes of the hearing today. The plaintiff is Eric Johnson. Mr. Johnson, as it relates specifically to the facts of this case, obviously is a member of the public, but he is also a board member of the Thurston Conservation District. The defendant is the Washington State University, but specifically as it relates to this case, I'm looking at the actions of the Washington State University Energy Program Office, and it's one of the satellite offices for Washington State University. It provides technology services to different entities that contract with it or have memorandums of understanding with it. And as part of those different services that it can provide, It provides servers and backup servers and storage for different entities. Washington State University itself, because the Energy Program Office is simply part of Washington State University, and again, it has satellite offices throughout the state. The Washington State University has created an Office of Public Records. That office is located on the main campus of WSU in Pullman. RCW 4256040 indicates that a state is required to publish rules to outline how public records requests may be obtained under the Public Records Act. And so it's required to establish protocols. Washington State University did that under Washington Administrative Code 504-45-020, which specifically details how public records requests can be made to the university. It references the Public Records Office. It gives a website and gives quite a bit of detail by way of that administrative code. And it's not disputed that in this case, the request in this case was not made to the Office of Public Records. The Washington State University has a has a system set up to deal with their public records requests through the Next Request system. It's an automated system. The request is logged in there. It sends where their responses are sent. People can track their public records requests through that program. Information can be provided through that program as well. On or about January 22, 2018, Michael Pearson, who is an information technology support specialist at the Energy Program Office in Thurston County, received a telephone call from Richard, I might say this last name correctly, Mancreamer, is that correct? Makemeyer, who is a board member of the Thurston Conservation District. He indicated that both himself and another person by the name of Eric Johnson, they wanted to come to the office, the Energy Programs facility. At that time, there was not any inference that this was a request to come in, view records, or that anything specific was being sought. Both, I believe that during that telephone call, it was identified that both individuals, Mr. Johnson and the other individual, were board members of Thurston Conservation District, and they were aware, of course, that records were maintained by the Energy Program Office. This was, according to Mr. Pearson, and these are my own words, not his, I didn't quote what he said, he was not quite sure what to make of this request, and so he spoke with his manager, Jim Colombo. He is the information technology manager, about the request that these two people come to the Energy Program Office to kind of view how they handle things in that office. And Mr. Pearson and Mr. Colombo wanted to verify that Mr. Johnson and the other individual were who they said they were. And of course, that seems like regular business procedure. And so they contacted Sarah Moorhead, who was the acting executive director for Thurston Conservation District. That makes sense. It makes sense that the Energy Program Office would want to verify who was coming into their facility. And it makes sense that they would contact Ms. Moorhead, who was the acting executive director, who would be the person that they had been having contact with as it related to Thurston Conservation District. On January 25th, Mr. Johnson came to the Energy Program Office. he met with Mr. Pearson and Mr. Colombo. Ms. Moorhead was present. She either was invited or had indicated that she wanted to be there. There was a general discussion on that date. Mr. Makemeyer.
Think of it that way.
Was present as well. The discussion was how can you obtain records. There was a discussion about setting up a computer so that those records could potentially be accessed related to Thurston Conservation District Network and the computers. The memorandum of understanding was addressed, and at some point at the conclusion of that conversation, or after the parties kind of separated after this review of the facility, Ms. Moorhead indicated that she wanted all requests to go through her. She was the acting executive director, and pursuant to the memorandum of understanding, I don't disagree with Mr. Newman, which was not the best memorandum of understanding I've ever read. That is how the parties proceeded. There was no specific request for any records during this January 25 interaction. On January 31, 2018, Mr. Johnson returned to the Energy Program Office. They were surprised to see him. He had not made an appointment on that occasion, and although he hadn't, Mr. Colombo met and spoke with Mr. Johnson, and at some point, Mr. Johnson was discussing about how he could get some metadata on some specific things that were Thurston Conservation District documents. Mr. Colombo indicates he was not clear on what was the discussion was actually trying to get at. Mr. Johnson has indicated by his materials that he believed that he was being clear. At the end of that, or during the course of that interaction, Mr. Johnson handed to Mr. Colombo 2 pieces of paper. They contained requests for records. That identical request was then also emailed to Mr. Colombo on January 31st. So the issue is whether or not either those handwritten pages and or the email, the first issue is whether or not those were a public records request, and whether or not that request was a fair notice to the Washington State University Energy Program Office that it was a public records request. Before I talk about that, it does appear to me that Mr. Johnson, through his pleadings and through argument from counsel, believes perhaps that the Washington State University Energy Program Office was somehow conspiring to keep documents from him. And there's nothing in this record that suggests that to this court. Washington State University Energy Program Office has no interest whatsoever in the very concerning issues that are in place at the Thurston Conservation District. That's why Mr. Johnson wanted the records, because he was very concerned about what's happening there. Allegations were being made against him, and he wanted records so that he could know what was really going on, potentially, I think also, rightfully so, to find documents that might counteract some of the allegations against him and the like. He was making his request for records in good faith, and there's nothing to suggest from this court's perspective that the Energy Program Office was doing anything in bad faith. And I say that because from my perspective, it appears that Mr. Pearson and Mr. Colombo were trying to act under the Memorandum of Understanding. Now that wasn't necessarily the right course of action they should have taken, but it does not appear to me, as was argued, that they were colluding with Ms. Moorhead. With that said, on Friday, February 2nd, Mr. Pearson said, Ms. Moorhead sent an email to Mr. Pearson, and she entitled it PDR, Public Disclosure Requests and Board Members. Ms. Moorhead was clear that Mr. Johnson's request was a public records request. And her discussions with Mr. Pearson, at least, clearly identify it as a public disclosure request. And she was asking that public disclosure requests go through her, which of course she has no authority to do, and she has no ability to countervene the Public Records Act. It is not credible to this court that by the time the request was made, after there had been a discussion about why Mr. Johnson was seeking these records, which he did discuss at a minimum with Mr. Colombo on the 31st, that Mr. Colombo would not have known that Mr. Johnson was not making his request pursuant to his role at the Thurston Conservation District, and that, in fact, he was making a public records request. And at a minimum, Mr. Colombo, Mr. Pearson, anyone at the Energy Program Office should have told Mr. Johnson, we have a public records office, this is where you submit your request. And they didn't do that, and instead they actually did start gathering the documents, but trying to do it through Ms. Moorhead. And so in this court's mind, clearly they did know that Mr. Johnson's request was a request for public records, and they were sending them to Ms. Moorhead, I guess because they thought that that was what they were required to do under the Memorandum of Understanding, although the Memorandum of Understanding does not address public records requests at all. Those records were gathered, emails were sent to Ms. Moorhead. Mr. Johnson followed up when he didn't receive a response, although he had been told that the records could be gathered in a short period of time, wondering if he was going to get a response. Mr. Colombo responded to that email on February 8 and indicated in that email, all public information requests must come through the director of Thurston Conservation District. So in that email, Mr. Colombo is indicating that he understands that this is a request for public information, that this is not a request through the Memorandum of Understanding. And again, this would have been an opportunity for Mr. Colombo to let Mr. Johnson know that perhaps he even had another remedy. If they thought it had to go through Ms. Moorhead, they could have referred Mr. Johnson to the Public Records Office. So as it relates to whether or not there was fair notice that this was a request for public information, clearly there was fair notice. The WSU's argument is that because it was not submitted to the public records officer, that made it invalid, which is really what the Parmalee decision indicated. In the Parmalee decision, Mr. Parmalee was an inmate. He had provided two different requests to two different people who had no connection to public records requests, and ultimately the court found that because he did not submit that the Public Records Act requires that agencies publish how these requests should be made, and that those had been published in that case, and that Mr. Parmalee's argument that there should be this broader interpretation of what the term office meant was unpersuasive to the court. He had not made his requests pursuant to that, the Washington Administrative Code, and so they were not going to find a violation or that it was a valid request. What I find is somewhat distinguishable is that clearly Mr. Johnson did not make a request pursuant to the procedure set up by WSU and did not contact their Public Records Office. Everyone knows that the Public Records Act is a strongly worded mandate for broad disclosure of public records, and that the disclosure provisions should be liberally construed and exemptions narrowly construed. The people in the Energy Program Office understood this was a request for public records and public information. And at a minimum, if they weren't going to process that request, they had a duty to either tell Mr. Johnson, we're not going to process this because you've made it to the wrong place, or they should have sent it to the Public Records Office. I think that that's what, that is what the Public Records Act requires. And it did not happen in this case in either format. And unlike the Parmalee case, Mr. Johnson was making the request to the place that like literally held the records. And so it is not, it seems very reasonable that he would believe, absent being told differently, that that is how he should make his request, or where he would make his request. So we have this request, and so then the issue is it a public records request? And the issue from the, raised by the defendant is an agency's storage of records on a server for a second public agency mean that the records stored are the storing agency's public records that must be produced in response to a public records request to the agency that is storing the records? This issue has not been decided. I actually think this is a very interesting issue. And I think that because although I know that the Public Records Act is this strongly worded mandate that it is for broad disclosure of public records, and clearly we have just a long list of case law on that issue. Just logically, it makes sense that a public, someone who wants public records from a public agency would go to that agency and request them, and that they would not go to this third-party entity to seek out those records when they are simply the person who's storing those records. But as Mr. Newman points out, and this is not some third-party entity, some private server. Thurston Conservation District chose to have this memorandum of understanding, chose to have their documents stored with a public agency. A public agency choosing a public agency to store their records. And RCW 4256.010 subsection 3 defines a public record. It includes any writing, everyone agrees that this was a writing, containing information relating to the conduct of government or the performance of any governmental or proprietary functions. And what the state argued in their brief is that they said they don't have any specific information on that. But for the purposes of argument, they will believe that the records are relating to government conduct or the performance of any governmental or proprietary functions. And then that are prepared, they were not prepared by the Energy Program Office, so that doesn't apply. Owned, they're not owned by the Energy Program Office, so that doesn't apply. Used, they're not used by the Energy Program Office, simply stored there. But the statute goes on to say, or retained by any state or local agency regardless of physical form or characteristics. This statute is clear on its face. It is clear that the legislature picked these words. And there is nothing that defines retain as anything other than what would be a normal definition. And again, in Nissen versus Pierce County, they briefly talk about retain. They're looking at other words more specifically. And they said because it's not defined, we would use a simple definition from basically a dictionary. Every single dictionary that this court looked at, as I've already indicated, indicates that retain is to keep possession of. That's it, without to keep possession of. And as the state argues, and I don't think it's a bad argument, but when a statute is unambiguous, I don't think I can read into it something that the legislature didn't put there, because I think it's a reasonable argument that the retain should apply, retained to the work that they are doing, or that an agency is doing, so it wouldn't apply to this third party. But that's not what the legislature said. And additionally, the legislature specifically said retained by a state or local agency. And so clearly this doesn't apply to this private third-party entity, but it does apply to any state or local agency that chooses to retain records. And so I will not, as the state has argued, adopt a broader definition of public records as it relates to the word retain. Although, again, I think that makes a reasonable result for me to do that. I don't think that that is how the law is written, and that I should go beyond plain language of a statute. So I do find that this, the documents sought were public records, as is defined by the statute. It's next been argued that there was no denial or failure to produce records, and that the email of February 8th was not a denial. That communication directed Mr. Johnson through Ms. Moorhead, or to make a request through the Conservation District. And if he went through the proper channels, they would be happy to produce the records. In fact, that was a denial, because the other thing they could have done was said, if you make the request through the Public Records Office, that could be different. Or that's another option that you have. And again, I don't believe that Mr. Pearson or Mr. Colombo or anyone in the Energy Program Office were acting in bad faith. I think they were acting without properly, perhaps, educating themselves or asking questions of other people. There's also nothing in this record to suggest that they didn't know anything about the Public Records Office that exists at WSU. Were all of the records produced? There were multiple, once the records started being produced to Mr. Johnson, which WSU did, once the records office was provided with a copy of those requests, once this lawsuit was filed, they immediately and timely began searching for those records. Mr. Johnson received multiple, people are referring them to dumps, but multiple separate productions of records, and he received thousands of pages of records. After the opening brief was filed, something in that brief made the Public Records Office or the lawyer contact the Public Records Office and say, hey, are there any documents that are missing? There was a check. There were documents missing. No bad faith that those are withheld. There obviously was a problem in the system in providing those, and they were timely filed, provided to Mr. Johnson, and that was that 34 documents were provided instead of 348 documents. So at the time of this hearing, the issue is whether or not the metadata to the first request was request specifically looking at an email created at TCD on November 29, 2017 at 3:33 p.m. and modified on November 30, 2017 at 9:47 a.m. What computer was this created on? That's no requirement to respond to that. Who created this? No requirement to respond to that. Those are not public records requests. Those are requests for information, which are different. And where was it sent? No requirement to respond to that question. A copy of this email and metadata, that's the request for the record, and that's what makes it the public records request. That document that was sought does not exist. And there's nothing that is vague in this request for records. The department or the agency that receives the request for a record is required to seek clarification if there's something that does not, that's not clear about it. And frankly, sometimes I think that there's a request for clarification when the request seems pretty clear, and I don't mean that for this, anything related to Washington State University. But this record is very clear on its face. It asks for a very specific record with dates and times. It does not exist. And so the fact, and this is the public records request. At this point, that public records request has been filled because the response was this document does not exist. With that said, it's very clear with the reply at a minimum that Mr. Johnson wants the metadata associated with the email and the document attached to the email. That was clear to me as I read these pleadings. And now that that's clarified, even though I don't think there was any confusion, Washington State University, unless they want potentially further litigation or further problems, should just go ahead and provide that. I'm not ordering them to do that because I'm not finding that has not been, I'm finding that this request has been properly responded to, but it seems somewhat absurd to me that when it has been clear for a week what Mr. Johnson was really submitting, regardless of whether or not he worded it perfectly, that at this point in this litigation it would not have been provided. And if the department, if WSU is not going to provide it at this time, they should immediately tell Mr. Johnson so that he can make another request through the Public Records Office. It is clear that Washington State University did not respond within 5 days to Mr. Johnson's public records request, and in that way did not produce the documents in a timely fashion. Once they started processing the request, once this lawsuit was filed, they have now provided all of the documents that were requested pursuant to the January 31, 2018 request. Any issues I have not addressed, Mr. Newman?
Just one point of clarification, Your Honor. For the record, Exhibit G, in my opening brief, is a email from Mr. Pearson to Ms. Moorhead where he says, as Eric and or the board have no memorandum of understanding with us. So just so the court is aware, according to Mr. Pearson, there was no memorandum of understanding in place at the time.
Well, semantics, there was a memorandum between Conservation District and the Energy Conservation District. I think that what the reference was in that email is that those individuals are not specifically mentioned in the memorandum of understanding, but it doesn't matter because I found that it was a public records request and that it wasn't properly fulfilled.
Just one other clarification. The metadata issue, as I mentioned in my opening brief, I referenced a specific email, and that is in my opening brief, and obviously my response brief reply, I'm sorry, I was surprised that WSU actually attached it and then still maintained they couldn't find it. So I wanted it just to make sure the record is clear that
I don't want to hear further argument. I was
Okay.
just asking whether or not there was any specific issue I haven't ruled on. I heard your argument
Okay.
and I read the briefs.
Okay, thank you. I don't have any specific.
Mr. Fulner?
No, Your Honor.
All right. So, orders and additional hearing?
Your Honor,
Or do we already have that date set?
we already have the date set. The briefing schedule is set forth. The next hearing is July 20th.
All right. I will see the parties at that time, and I can enter the order from this hearing at that time as well. Or maybe you're just going to do one order in its totality.
I think we'll just talk about an order. I do want to order the transcript though.
All right, thank you.